Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London, and today I'm looking at a book which has come to us from Sweet Maxwell, the Thomson Reuters organisation. It's a book which we've seen and looked at before, but it's now in a new edition, and it's called Ross on Inheritance Act Claims. It's now in a fourth edition, and it's been edited by Sidney Ross. Elizabeth and I have talked about the book and about the subject matter of Inheritance Act claims, which is also one of the most difficult areas of law for many practitioners, because it brings out the very worst in human nature sometimes. That's one of the problems with this particular area, and that's why this book I think is most helpful, because it sets the record very clearly out as to how one goes about making claims and how the system really operates. Now, Elizabeth and I have given a title for our review: Problems with Wills, Read Ross, now in a new fourth edition from Sweet Maxwell. Well, before we do anything else, let's have a look at the book. It's here, it's this book here, and it's part of the Trusts, Wills and Probate Library. You can see the information there on the spine. There's nothing else actually on the back at all apart from the ISBN, but as it says, from Sweet Maxwell. The book itself is heavy. It's a hardback, purple cover, and it runs to something approaching 700 pages. The index at the back, which you can see, it's standard house style, again for Sweet Maxwell. You've got paragraph numbering, and it's a detailed index at the back, and they will explain, normally they do. They don't on this occasion, of course, having said they do. The index is there. Normally they explain that it's by paragraph numbering. They haven't here, but that's what you've got, okay? Now, what you do have is the paragraph numbering clearly shown at the sides. Again, very much the house style that we've come to expect, running all the way through. Plenty of appendices and examples. And again, you can see as we move through the book, quite a lot of information, and you will also see that there are footnotes. Fortunately, there are not excessive footnotes, which I think is a great help. There is the front page of the book, and as I said, it's part of Trusts, Wills and Probate Library. The first edition was in 1993. There's the blurb about the book there, all the details, and then there's a foreword by Lord Justice Henderson LJ, and he sets out, Lancelot Henderson sets out where we are at the moment with this particular book. His comments are actually, the foreword is actually dated the 1st of September 2017. He said, Mr. Ross's book has long played an important role in that illustrious tradition. That's of the Chancery Bar. I have every confidence it will continue to do so. It certainly does. There's the preface after that, which comes from the author. And he's at 10 Old Square, Lincoln's Inn, 30th of June 2017. I'm recording this at the beginning of 2018, this review. There's the contents section. You can see there, and then some appendices, and then after that you've got the table of abbreviations, very helpful in this particular area, which I found very helpful. You see the abbreviations there. Then you've got what's called short titles of books and reports, which have been used. These are the specialist publications which Chancery practitioners will be very familiar with. Those who are not part of the Chancery practitioner grouping will actually find this information very helpful. For instance, you've got Lewin. The actual names of the particular publications are like Lewin, just named, and then after that you've got McCutcheon, for instance, as well. You've got them all there listed, and then the detail about them is afterwards. Then you've got transcripts of unreported cases as well, which we have a few. And then after that we then get to the main table of cases there, which there are a lot, of course, and then after that, table of statutes to be expected, and guess what we get after that? Table of statutory instruments, and so forth. And then after that, we then get to the book itself. You see how it's structured? Chapter 1, and you've got an index. So you've got an index right at the beginning, which should make it very easy for you to find what you're looking for. Then you've got the paragraph numbering at the sides there, and then it runs through, and you can see a little bit of footnoting as we run through the 700 odd pages. Well, there it is, a very good book. Now, what do we have to say about this book? Apart from the fact that I'm trying to get it to stand up. There we go. Well, we say this. Long established over more than 24 years, this now classic and authoritative legal text by Sidney Ross is now available from Sweet Maxwell in a new 4th edition, which incorporates all significant developments in what's a changing area of law since the previous edition came out in 2011. And can I just say that whilst we say it's a changing area of law, it is not changing in quite the same way perhaps as a lot of the common law areas are. And that's rather nice because there's a little bit more stability. But having said that, of course, what you do have is you do have changes, and you've got to keep up to date with the information as it comes in. Of course, we do have an expanded amount of case law authorities as well. So writing in the foreword, Lord Justice Henderson pays tribute to the book, quote, as an invaluable companion and resource, not least for its very full and user-friendly treatment of the case law, which has evolved in what he calls a steady stream over the last 4 decades. And of course that, as I say, has been the case. I remember at bar school that certainly in this area of law there were not the big changes that we were expecting and of course getting in, as I say, the common law, the main common law area. So fundamentally the book, as the author describes it, is about claims under the Inheritance Provisions for Family Independence Act 1975, which is known as the 1975 Act. And of course we're obviously all familiar with that Act, but this is the detail concerning it, and its scope must extend to the other types of claims, the author adds, which may arise on the death of the person out of whose estate financial provision is claimed under the Act. And you can see the whole purpose of this is to look after certain categories of person who would be entitled to make some sort of claim. And of course that does change in many ways through parliamentary intervention what was a rather more draconian basic structure in the old Chancery practice, but I'm going back, of course, rather a long time. So what we've got today is this is an area of law which certainly reveals an especially conspicuous complexity as evidenced in the recent amendments to the 1975 Act, and the examples given, for instance, the myriad complications of multiple claims, numerous instances of which are introduced at the beginning in Chapter 1, entitled What Claims May Be Made on Death? The leading question which you will get as a practitioner. The chapter ends notably with a section on to do and not to do, which, like much of the book, combines fascinating and necessary cautions with practical advice. And a striking feature of claims under the 1975 Act, says Henderson, is the way in which they require the skills of an expert family lawyer, sometimes the skills of a chancery practitioner, and not infrequently a combination of both. And I have to say, having been involved in this area, although I'm predominantly a common law practitioner and family practitioner, he's absolutely right, because they overlap. Now, it's for this reason that Henderson then goes on to add that claims under the Act may be brought in either the Chancery, that's recently renamed as the Business and Property Division or Courts, or the Family Division or Family Courts. We are seeing changes taking place, and the Business and Property Court, which I do practice in, is changing all the time, and there have been some extremely interesting, innovative new changes throughout 2017. And here then is an area where Chancery and family practice in many cases are inextricably linked. And I think it's always dangerous to try and compartmentalise particular areas, and there has been a move afoot for sometimes to perhaps change the name of Chancery to something that is a little bit more understandable for the ordinary members of the public. I have a feeling that's probably going to be resisted, but there we go. And if anything should convince you to get this book into your professional library, then it's the vast repository of research resources which it contains, particularly the 6 appendices, the first of which is the 1975 Act. And the 5 following include this: inheritance rights for cohabitants, again being looked at the moment, rules, orders and form, questionnaires and important cases, followed by over 160 pages of case summaries and Appendix 6. And the appendices are quite substantial in this document. We'll have a look at them again in a minute in this book. These last are an important, I think, and useful feature in that they contain references and case notes referring to specific cases grouped in 13 sections by subject. And I think it's also important to note the 4 tables at the front of abbreviations, cases, statutes and statutory instruments, which I showed you at the beginning. Now let me conclude by saying this: for Chancery practitioners and family lawyers alike, and indeed all practitioners, this meticulously updated new edition of Ross is an essential work of reference, and I'm calling it Ross on Inheritance Act claims, because I think that's the correct, I don't actually say that, but that's what you're getting as part of this Trust, Wills and Probate Library. So as I say, it's meticulously updated and is essential. Fortuitously, the book also includes the Supreme Court judgment of Elliott and Mitson, delivered on the 1st of March 2017. There's been a huge amount written about it in the law press, and I'm sure everybody is fairly familiar with it. And obviously it came out just prior to the date of publication, which is actually now cited as at the 30th of June 2017. And we will be seeing the various changes that take place as a result of that particular case in due course. Here's the book again anyway, there's the front of it. Now, as I said, just going into it, the appendices are quite important because we start the appendices actually on page 473 out of the 700. So you can see it's that amount which is the appendices themselves. Obviously it has the Act specifically, and it's got rules, orders and forms and so forth. So there's a lot of information, the questionnaires, all that information that you need, which of course will be in here. A lot of it will be in here as well, in the white book, but you do have that information. And then just opening it a bit here, a bit earlier, chapter 7, offers to settle. You can see there is a lot of practical information in here, but as I've said with many of these Sweet and Maxwell titles, this is where the law is. People often ask me, where's the law? How do we find it and so forth? Is it in Parliament? Is it where is it? But it's actually these books from Sweet and Maxwell which, if any, are the most important, because they are effectively the most important authoritative statements on where we are in 2018 on specific areas of law. Obviously the common law library is the biggest single area, but they do have these other libraries which they also publish information from, and without that information our lives would be much more difficult. So a big thank you to everybody who's been involved in this new title. Thank you very much. Bye bye.